I know 5 and 6 lossy may not like.
List these cases before any other times without.
Yes, for listing tomorrow, man. For listing my tomorrow.
Most by to use
Tender better my
on. I never know how it is. Huh? Yes.
my lord. I will mention for listing tomorrow, my lord. The tender better my lord.
When?
Tomorrow, my lord.
Motion.
Lordship. Master plan.
May I please, your lordship? Lordship, I beg to mention for listing of a petition, your lordship, for admission, your lordship.
For
Admission.
admission. Okay. Next page.
Obliged.
I will circular clear tender matter on the next week, next Monday.
Is the lordship, I beg to mention two items for listing for admission.
Subject matter.
One is related to
Huh?
payment
Yes.
of wages act. One is related to payment of wages act. And the other one is for fair price stock.
Okay. Next page. Eh, na na. Na.
Hello. Hello. Hello.
Colony করা নাই নি colony করা নাই এই আইনাখন গুজাই দিলে কোথায় জানো
বন্ধ আছে
হ্যাঁ ওকে
For withdrawal, item number 8.
you want to withdraw
Yes.
MS
Okay, Malakot.
K. Malakar Council for the petitioner has submitted on instruction from the petitioner wants to withdraw the petition. Mr.
S. Rava, my lord. My lord, my name is wrongly listed in the petitioner's list. It should be for
S. Rava.
respondent number 3.
Mr. S. Raval, Council for the respondent number 3
Respondent number 3.
is present. In view of the above submission made by MS Malakar and Council for the petition, the petition is dismissed on withdrawal.
Obliged.
For orders, item number 1.
Yes. Mr. Hawk, just a minute, mic is not working. The mic is not working. এই হেৰি কৰিব এই আইনাখন গুচাই দিব দিব এই আইনাখন লগাই থোৱা আছে কাৰণ আইনা গুচাই এইখন গুচাই দিব এদিনৰ কামটো এদিনৰ কাম কোনোবা এদিন শনিবাৰে আমি কৰিম। Mr. Chaudhary, please take your seat. Something is wrong. Am I audible?
Yeah, my lordship.
On that part, that side it is okay.
Something
That's
wrong
right.
with the mic probably on this side.
দুইটা কেনেকে যাব কেনেকে যাব এতিয়া মানুহ Yes, Mr. Hawk will try. Speak a bit louder.
Maybe he can come on this side, my lords.
Yes. Maybe for the time being.
Vinay, Vinay, sir.
My lord, it's totally not here.
Yes,
I'm not, it's not working.
okay. Speak louder.
Vinay.
Yes, now. Well, here, well, the basically, well, I was filed well, for registration of electricity connection. Well, in terms of other dated, well, in fact, they have restored the connection, well, electricity connection, but temporary connection, well,
Hmm?
causing now, my lord, petitioner has been reconnected with the temporary electricity connection, my lord.
What is the case?
Well, then, Lakshmi, kindly,
Come to read petition,
my
Isha.
lord, my lord. Here, my lord, the petitioner, my lord, is the owner of flat, my lord, and 6 mile area, my lord. Here, my lord, he had possessed the flat in the 2014, my lord.
Purchase the flat number, eight type, fifth floor, Nihal in Cape Market. Let's represent a plot of land.
Now, that flat was enjoying, my lord, temporary connection, well. Now, while the temporary connection is causing, my lord, huge amount of money, my lord. At its surcharge, my lord, electricity bill, my lord. So, my lord, the petitioner has applied for regular connection, my lord, normal electricity connection. My lord, now, my lord, the APTCL, my lord, had raised the objection, my lord, that you don't have the no objection certificate from the builder, so you are not getting, my lord.
Yes, Mr. Chaudhary. Who is for Response number 5? Yes. Tell me first. Why you are not providing temporary connection, electricity connection to
No
the
objection.
flat owners?
Lordship, today we have awaiting first time lordship. Instruction may be awaited lordship. Instruction is awaited lordship.
What instructions? He is not providing, the builder not providing
Yes.
facilities,
The NOC, my lord.
NOC.
Yes, sir.
Lordship, 4 weeks time may be granted.
No 4 weeks time, no 4 weeks time. Petitioners are suffering because of your action.
Lordship, instruction is awaited for the lordship. Kindly sometime may be given lordship. Instruction is awaited lordship. For the lordship, kindly
Only 1 day's time.
1 week may be lordship.
Yes, Mr. Chaudhary.
My lords, the issue otherwise is, they purchased the flat, my lords. What the issue?
They are
is,
occupying.
They are occupying it. We wanted to give them a permanent connection. We could not because they have not executed a sale deed. Now, what the builder has done, my lords, they have not executed a sale deed. So there is no valid document in favor of the petitioner, my lords. Now, they have
Agreement.
they have an agreement in place. They have a temporary connection.
So at least their bona fide is there.
Bona fide is there, my lords. Para 3 of their petition, my lords,
There are 3.
at page 5, my lords. But bottom of para 3, my lords. But till date, the said builder has not executed the final sale deed in favor of the petitioner.
He has taken housing loan.
Yes, my lords.
Already petitioner has paid all the money.
And this deposit you are taking, it is a bit higher.
It is higher. It is a temporary connection, my lord. There is security amount is higher. My lord.
And normal tariff also, my
So if it is otherwise bona fide occupier, if he is bona fide occupier of the premises, it seems,
My lord. My lord,
then without insisting for an NOC, you can
my
give
lords,
it.
that direction, my lords may pass, my lords, subject to what my lordship holds.
Yes, you take your instruction by day after tomorrow.
Otherwise, that judgment of Dilip Singh. my lord,
Yes.
probably.
Will apply. But why, let me find out why
My lord.
the builder is not giving. Day after tomorrow. Miss MS, Mr. S. Hawk, learned counsel for the petitioner. Mr. K. Gugoi, learned additional senior government advocate Assam for the response number 1. Mr. D. Chaudhary, learned standing counsel APDCL for the response number 2, 3, 4 are present. MS,
and Bora Lordship.
N Bora, learned counsel appearing for
Respondent of 5.
5. As sought for listing of the case day after tomorrow to obtain necessary instructions in the matter.
Lordship,
The
I
subject matter of the writ petition is electricity connection to the flat purchased by the petitioners from the respondent number of sorry, which situated in the multi-storied apartment building constructed by the respondent of 5 as a builder developer.
Lordship, I copy maybe serve open after.
Yes, Mr. Hawk. Sir, both copies of Mr. Hawk, learned counsel for the petitioner, self-furnished a copy of the writ petition with annex and a copy of the IA along with annex to MS Bora during the course of the day.
I may be discussed, in fact, I have been, I my lord, the I business file, my lord, that has become infectious.
Okay. Writ petition. During the course of the day, Mr. Hawk, learned counsel for the applicant petitioner, that the interlocutory application, subject matter of the interlocutory application has been particular. Mr. K. Google liখিব. Opposite party number 1, B. Chaudhary, standing as the deputy cell. Opposite party number 2, 3, and 4, and Miss R. Bora, learned counsel for the opposite party number 5. Are in attendance. In view of the above submission, with back to answer, the interlocutory application is dismissed as impact trust.
For hearing item number 2.
Speak out.
My lord, I have some difficulties today, my lord.
Or we see, I don't tell you when it comes. বলছি ভালকে আহা নাই আপুনি কাৰোবাক কওকচোন
One.
who is for the respondent?
Lordship, I am for respondent number 1.
Okay,
Page 31.
please read.
This reference was received from Government of Assam by notification number GLR 70 dated 17/7/2007 for adjudication of the issue framed by it. The issue was as under. Whether the management of Kumtai Tea Estate, Post Office Badulipar, District Golaghat is justified in dismissing the service of Sri Shimanta Kotoki, workman with effect from 12/4/2005. 2. If not, is the said workman entitled to reinstatement with full back wages or any other relief in lieu thereof? Upon receipt of the reference case number 10 of 2007 was registered thereon and notices were issued to both the sides asking them to file their WS and the documents they intended to rely on. Accordingly, the management side submitted his WS and additional WS on 18/2008, 23/4/2008, 16/11/2009 respectively. While the Sangha submitted his WS and additional WS on 13/2/2008 and 11/6/2008 respectively. The case of the Sangha is as under. On 14/8/2004, the management issued notice, and on 29/11/2004, it issued search sheet to the workman alleging that he had misappropriated 30691 liter of high-speed diesel worth rupees 6,25,088 during the period from 1/4/2003 to 31/7/2004. However, the workman was not at all involved in the said act. In fact, it was the factory engineer, deputy manager who received the oil vouchers, unloaded and concerned oil tanker and filled it in the factory fuel preserve tank of SST. The deputy manager used to check the oil tankers before and after unloading by signing the proper challan, and after that, 1 copy of the challan was used to be handed over to driver and 2 copies to the senior storekeeper. The SST oil reservoir tank was kept within well fenced boundary and in tight security with lock and key. So there was no question of SSD being stolen, and the workman has no scope to receive the oil from the oil reservoir. Any requisition slip for SSD was mainly written by the head fitter and was signed by the factory manager, while the basic duty of the store clerk was simply to issue SSD or any other material to the bearer on receipt of proper requisition slip. In what way the SSD was used by the authority in day-to-day work was not looked into by the store clerk, nor had he got any authority to interfere. And this matter could be explained only by the concerned person involved with the tea factory and its management. The store clerk maintained the stock ledger of SSD as per requisition slip, and physical stock of SSD tank was checked by the concerned authority, that is the factory manager. As per audit report dated 14/8/2004, Powerhouse had not maintained a proper record. However, the workman was not responsible for that. He was liable to explain only regarding the issue and stock register which were kept in the custody of the management. Moreover, when persons like factory manager and storekeeper were there, the store clerk was in no way responsible. The SSD oil preserver tank were not properly checked and maintained periodically by unloading the oil from tank to see whether there was any leakage at the base of the tank. Serial number 1 dated 14/7/03 of the letter dated 14/8/04 issued by the senior manager of Kumtai Tea Estate mentioned about SSD being issued without requisition, but the factory manager had signed the stock issue register after proper verification. By letter dated 6/1/2005 issued by the management, the workman was asked to attend a domestic inquiry held on 29/1/2005. Copy of the domestic inquiry proceeding and the final report were not provided to the workman, and he was also not given chance of defending himself by perusing the same. So his dismissal was unfair, illegal. Moreover, no criminal case has been filed by the management regarding the alleged offences. Though senior storekeeper Babul Bora was sole in charge of the store, he as well as factory manager were not implicated in the case. Hence, the prayer to decide the issue in favor of the workman and to reinstatement him with full back wages and other incentive, if any. The case of the management is as under. The workman was charged for gross misconduct. His explanation thereto was not found satisfactory. Accordingly, the management held a domestic inquiry into the said charges on 29/1/2005 by an independent inquiry officer. The inquiry was held in presence of the workman as well as the independent observer and others according to the principles of natural justice. The inquiry officer found the workman guilty of the said charges. The management concurred with the said finding but gave an opportunity of personal hearing to the workman on 4/3/2005. The workman attended the hearing, but no extenuating circumstances was found to take a lenient view. All the allegations of the Sangha made in the WS except those about the workman being charged, about a domestic inquiry being held against the workman, holding him guilty and leading to his dismissal from service, about the oil preserver tank not being properly checked periodically to see if there was any leakage at its base, about the storekeeper Babul Bora and the factory manager is not being implicated in the case, and about serial number 1 dated 24/7/03 of the letter dated 14/8/2004 issued by the senior manager of Kumtai Tea Estate, mentioning about SSD being issued without requisition, despite the fact that the factory manager signed the stock issue register after proper verification, are denied. The management lost confidence on the workman Accordingly, by his letter dated 12/4/2005, the management dismissed the workman from his service in the larger interest of maintaining discipline at the tea estate. The management action of dismissing the workman was right, valid, and bona fide. The workman brought the dispute before the concerned authority very late, and as such, he had waived his right to this dispute. So he is not entitled to reinstatement in his service or any other relief. Hence, the prayer to decide the issue in favor of the management. The management side examined two witnesses in support of his plea. The Sangha examined one. Both the learned counsel led me through the WS and the evidence of both the sides and made detailed submission, argument in support of their respective various plea taken therein. Also perused the case record, including the evidence recorded therein. Issue number one. Let me first see whether domestic inquiry held by the management was valid one. The witnesses have deposed for the management side regarding the domestic inquiry. MW2's name is recorded by this court in the deposition about sheet as Bhargav Bhushan Bura, senior manager of Kumtai Tea Estate. However, the witnesses have signed the deposition sheet as Bharat Bhushan Bawa. On perusal of the Hajida of the management file on that day, it is seen that one B.B. Bawa was present in the court on that day as witness. The charge sheet exhibit 4 of the management reveals that it was signed for the management by one Bharat Bhushan Bawa, senior manager of Kumtai Tea Estate. So it is clear that MW2 was Bharat Bhushan Bawa, senior manager Kumtai Tea Estate. And this court, by mistake, recorded his name in the deposition sheet as Bhargav Bhushan Bawa. In his deposition, he says that Exhibit A's charge sheet was issued to the workman, and the workman responded by filing Exhibit 1 reply thereto. He further says that, being not satisfied with his reply, the workman was informed about their proposed inquiry by virtue of Exhibit Y letter. And thereafter, Exhibit K notice of inquiry was issued to him. According to him, as the inquiry could not be held on the date fixed, the workman was informed about the adjournment by Exhibit 1 letter, and then he was given Exhibit M notice of inquiry. He claimed that the inquiry was held by the inquiry officer, and he found the workman guilty. He averred that Exhibit O, second show cause notice, was personal hearing was given to the workman and his partial submission thereto being found not satisfactory. He was dismissed from his service by virtue of Exhibit P dismissal letter. At MW1, Audhi Chandra Roy claimed that he, along with Birinshi Kumar Sharma, was present as observer in the inquiry, and their appointment as observer was not objected to by the workman. He says that the inquiry was conducted in presence of the workman and that the workman was allowed to cross-examine. After being recorded, the evidence of the MW was laid over to the workman. The above claim of MW1 and MW2 are not in dispute. Though in their evidence, the MW do not specifically say that the inquiry was held in accordance with the principle of natural justice. The above discussion of the evidence show that the inquiry was held according to the relevant procedure, and their evidence does not show that the principle of natural justice was violated in conducting the inquiry. On the other hand, the workman does not say in his evidence that inquiry was not held in accordance to the principle of natural justice, but he claims that he was not heard before being dismissed from service. However, my attention has been drawn to the fact that the said plea was not specifically taken in the WS. On the other hand, in his WS, the management clearly claimed that after concurring with the finding of the inquiry officer, the management gave an opportunity of personal hearing to the workman on 4/3/2005, and the workman attended that hearing, but no extenuating circumstances was found to take a lenient view. In his WS, Sangha did not dispute the said claim of the management side made in WS. In his evidence also, MW2, Bharat Bhushan Bawa, senior manager of Kumtai Tea Estate, claimed that after the inquiry Exhibit O, second show cause notice was for personal hearing was given to the workman, and the workman made verbal submission in respect thereof. But his such submission being found not satisfactory, he was dismissed from his service. On perusal, it is seen that Exhibit O is in fact second show cause notice issued to the workman. This said claim of MW1 are not disputed by the Sangha during his cross-examination. It is also not the case of the Sangha that Exhibit O was not a genuine document or that the workman did not receive Exhibit O. In view of the above, it cannot be held that the workman was not given opportunity of being heard before being dismissed from the service. So the domestic inquiry cannot be held to be invalid on that count. The Sangha has also claimed in this WS that copy of the domestic inquiry proceeding and file and report, that is finding of the inquiry, were not provided to the workman. It was not given to the workman. Examined as workman witness 1, the workman himself supports that claim made in the WS. This said claim was not denied by the management side in the WS and evidence. Hence, so the fact stands satisfactorily established. Let us now find out the effect of such non-forensic of the above mentioned two documents to the said workman on the validity of the order of the management terminating his service. In decision rendered by their lordship, Honorable Mr. Justice so-and-so of the Apex Court, in 2010, 1 SCC C861, it was entirely held that right to show cause notice against penalty also represents right to represent against the finding of the charge. In Haryana Financial Corporation, 2008 2 SCC, this Honorable Apex Court held that non-supply of inquiry report would not ipso facto vitiate order of punishment in absence of any prejudice to the employee. It is not disputed that provision which require furnishing of their relevant document to a delinquent employee facing a domestic inquiry are procedural provision. Now in Amit Dewan versus State of Assam, reported in 2004, 1 GLZ 223, Honorable Justice of this High Court held that procedural provision are generally made for affording a reasonable and adequate opportunity to the delinquent officer, and they are conceived in his interest. His lordship further held that, however, violation of any or every procedural provision cannot be said to be automatically vitiate the inquiry, and complaint of violation of procedural provision will have to be judged from the point of view of prejudice. In Haryana Financial Corporation by Lord Kailashandra Ahuja, the Apex Court held that it is for the delinquent employee to plead and prove that non-supply of finding of inquiry has caused prejudice and resulted in miscarriage of justice. In Sorba Uttar Prakash Damin Bank case referred to above, it has been held by the Honorable Apex Court that in all cases where procedural requirements are not complied with, prejudice must be proved and not presumed. Thus, from the decision referred to above, it is clear that though a second show cause notice is issued to an employee to give him an opportunity to show cause against the penalty that might be imposed on him, the second show cause notice does not give him right to represent against the finding of the charge. In other words, in response to the second show cause notice, an employee can challenge not only the quantum of punishment that might be imposed on him, but also finding of the inquiry officer holding him guilty. This above decision also makes it clear that non-furnishing of finding of a domestic inquiry and other procedural documents to a delinquent workman constitute only a procedural lapse, and it does not vitiate the domestic inquiry unless the concerned workman shows that such lapse has caused prejudice to him and has resulted in miscarriage of justice, and such prejudice be proved and not presumed, and that the burden to plead and prove such prejudice lies on the workman concerned. In the light of the above established principle of law, let us now find out whether non-supply domestic inquiry proceeding and a filing report cause prejudice to the workman. In WS of the Sangha has taken the plea that the workman was not given chance for his self-defense on perusal of said document. However, examined as workman witness 1, the workman has not uttered a single word in support of that plea. And to the state plea and so the state plea is the proof. Both even other ways, the above mentioned claim of the Sangha on the matter in the WS is a general claim, only it is unspecific and vague. The WS does not reveal in what way such supply of the concerned document, in what way non-supply of concerned document affected the defense of the workman. It even does not mention whether it affects his defense in representing his case regarding the quantum of punishment to be imposed on him, and in having his say in present in respect of the finding of inquiry itself holding him guilty of the charges. The WS doesn't mention that in absence of the said document, the workman could not submit an effective proposed reply before the order of dismissal was passed. There is also no evidence on record to show that the workman complained before the management, the inquiry officer, or the conciliation officer that he suffered prejudice because of non-supply of the said document. In view of the above discussion, I find and hold that workman is unable to discharge his burden of proving the non-supply of concerned documents that caused prejudice to him and had resulted in miscarriage of justice. And there is nothing in the evidence on record to show that workman suffered prejudice on account of the alleged lapses on part of the management. The validity of the domestic inquiry is not questioned on any ground. In view of the above, I find and held that the domestic inquiry was a valid one. In his evidence, MW2, manager of Kumtak, is the proof exhibit 8 as a charge sheet issued to the workman. According to the charge, the workman misappropriated 30 liters of SNC valued at rupees 6,25,000. It was a very serious misconduct and was proved in the domestic inquiry. In his WS, the manager claims that the loss of confidence to the workman. There is nothing in the WS of the Sangha suggesting that the management did not have reason to losing confidence of the workman. Now in UP State Transport Corporation case, their lordship of Apex Court held that misappropriating being a serious offense, Labor Court cannot, in exercise of its discretion, and alter the punishment of dismissal from service. In view of the above, I am of the considered opinion that punishment of dismissal from service imposed on the workman by the management is just and proper, and it is not liable to be interpreted by this court. Hence, I find and hold that management of Kumtak Estate is justified in dismissing the workman. Issue number 2. In view of the decision arrived at in respect of the issue number 1, I find and hold that workman is not entitled to reinstatement will file back wages or any other relief in the due development. So against this award, I am before your lordship.
Trial court discussed whose evidence?
And two evidence were examined by the management, my lord,
First one is,
workman. My lord.
the first one is
First one is
Mr.
MW,
Manager.
MW2, my lord,
No.
at page 35. MW2 is the manager. Page 35.
Thirty-five. Who is he?
Is-
Bhargav Bhushan Bora.
Bhargav Bhushan Bawa. He is the.
MW2.
Yes,
MW2.
he is the senior
MW2.
manager.
Senior manager. And MW1 is Odhir Chandra Roy.
Ajay Chandra Roy. He was observed in the inquiry.
But in a domestic inquiry proceeding,
That is my.
there were two other witnesses. Right. One is named management witness,
My,
Zitian Kurmi, MW1. And MW2 is Bonsidhar Kurmi. There was a presenting officer also. And this workman also adduced his own evidence.
own evidence. On the-
Right.
Yes.
Thereafter, the inquiry officer recorded his findings.
Yes,
And all those documents of domestic inquiry proceeding is available in the case record. So principle here from 35, it has emerged that the labor court has examined only the evidence laid before it.
my lord, here.
And
what-
on that basis has reached the finding that domestic inquiry held was proper.
It was not examined, and in fact, my lord, my prayer is that domestic inquiry proceeding and finding was not given to the.
That is one aspect, but
Yes.
firstly, whether in view of that I think the earlier case also,
Yes.
law is that
Settled.
labor code assumes jurisdiction to discuss the evidence laid before it only after it finds that the
Domestic
evidence,
inquiry.
domestic inquiry proceeding
It-
was in violation of principle of natural justice and all, right? But this labor code, in this case,
Yes.
he examined, they framed the two issues. First
Yes.
issue is okay, let me see whether the domestic inquiry held by the management was valid one. To examine this issue, I think he has to go to the domestic inquiry proceedings.
Yes. That he did not enter into, my lord.
That
Right.
ought to have been, unless he does not enter into,
He cannot go into.
he cannot
my-
assume jurisdiction to discuss this evidence.
Yes, that is my point, my lord, here.
That should be the,
Yes.
yes. First issue he framed is okay,
Gotcha.
page 35.
Gotcha.
Let me first see whether the domestic inquiry held by the management was valid one. Right? In view of all this Firestone, Tata, subsequently approved by constitution bench, that this framing of first issue is okay. But while examining the first issue and to record the finding, he has to go to the original domestic inquiry proceedings. There were two other witnesses, not these two. This Bhargav's Bhushan Bora, senior manager, and Odhir Chandra Roy, they did not adduce evidence in the domestic inquiry proceeding. Two other persons, their names are Hiten Kurmi and Bonsidhar Kurmi, they were management witnesses. They have adduced evidence. Or delinquent workman cross-examined them. Thereafter, he adduced evidence. There was a presenting officer. He exhibited about 15-20 documents. So to decide this issue, I think labor court ought to have discussed the materials as regards the original domestic proceeding, not the evidence laid before it. The law is that if the domestic, there is two stage before the labor code. First, he has to examine whether the domestic inquiry proceedings which led to the dismissal of the workman was held in conformity with the principles of natural justice, and whether the workman was given all the opportunities to defend his case. Now, he went on discussing MW1 and MW2 who deposed before labor court.
Lordship, I am for respond number 1, Lordship. Respond number 2 is the presiding officer, Labor Court, Lordship.
You are
I am for the management,
right.
Lordship.
Yes, where is Mr. Bokolial or Gogoi? Where is Gogoi? I think he was there on the. What do you say? Is this,
Lordship,
how do you defend it?
Lordship, in my opinion, Lordship, this domestic inquiry has not been challenged in this petition. That the domestic inquiry is.
No, question is jurisdictional issue.
Lordship,
Is it not challenged? What?
Lordship, the domestic inquiry report itself has not been challenged in the petition. The award has been challenged, saying that there has been violation of natural justice law.
Let us see. Leading. No. Paragraph 7.
Lordship, in the prayer part is not.
Huh?
Lordship, in the
And
prayer
let
part.
us see the WS.
Lordship,
WS. Because after the labor court received the reference,
Lordship,
what did it do? It issued notices,
Lordship,
right?
Lordship.
To both the parties. You can state by Walkman, Sangha. Walkman Sri Kotoki. Final report has not been provided to the workman, nor given any chance for self-defense for perusal of the proceeding. There are two WS, I think. On the other hand, management supported the domestic inquiry proceeding. There is additional WS from the management. Management further begs to submit that they intend to rely on the domestic inquiry held by the management first. And if the learned court hold that the domestic inquiry is not in order and violative of the principles of natural justice, they intend to lead evidence to prove their case on merit. So, in view of this overwhelming contentions made by both the sides, the duty on the part jurisdictional issue from the point of jurisdiction, the labor court ought to have examined the records of the domestic inquiry proceeding. He could not have examined the validity of the domestic inquiry proceeding on the basis of evidence laid before it. What do you say about that
Lordship, that's-
proposition?
Lordship, without going,
এই যে এই আমার ভট্টাচার্যের কেসটা ওটা কি আপনার এটা what is that Firestone and what
Firestone
Tata
case.
Tata
Yes,
Tata oil mill.
Tata. My lord, today I have not brought the decisions.
Lordship, in fact, there are two cases, Lordship. I have
Mr. Sahara it will take some time. We'll pass the order here. Yes. You can have say 30-40 minutes. Yes, which one?
It's clearly covers by Firestone case. It Firestone case covers my case.
Let's see Tata. I think it should have been labor court. I think the what was that? Firestone, right?
Firestone case, 70.
Delhi cloth. I'm sorry, Delhi cloth mill. Delhi cloth.
Delhi cloth mill हमारे लुटबुट सिंह मैडम.
Huh?
Delhi cloth mill versus लुटबुट सिंह मैडम.
Ludbut Singh. Paragraph 60. Paragraph 61. Let us see. One is not required. One is not required. Read two. Paragraph 61, do you have? Don't have.
No, not with me, my lord.
Okay. Yes, who is for the labor state? Do you have any idea, Mr. Bokolial?
Our name is not showing here, so the file is not with us. I have informed K. Gogoi. He may have some instruction money. He is in election court number 1.
Approach was MS Bhattacharya is somewhat correct, but first issue framed is correct, but the approach is wrong.
Yes.
Approach is incorrect. If we go by 3, when a management relies on the inquiry conducted by it and also simultaneously adduces evidence before the tribunal, this is okay. Without prejudice to its plea that the inquiry proceedings are proper, it is the duty of the tribunal in the first instance to consider whether the inquiry proceedings conducted by the management are valid and proper. If the tribunal is satisfied that the inquiry proceedings have been held properly and are valid, the question of considering the evidence
That's not the right.
adduced before it on merits no longer survives. But he had gone into the validity of the domestic inquiry proceeding, but through the evidence laid before it. This Vikas or Bora and something. He should have gone to the original proceeding.
If it is,
Issue framed is correct, but the approach, because it says, it is only when the evidence holds, tribunal holds, that the inquiry proceedings have not been properly held, then it derives to deal with the merits of the dispute.
yes,
And in such a case, it has to consider the evidence adduced before it by the management.
first, there must be. a
First, he has
finding
to
of-
deal with
yes,
the original case,
Domestic.
domestic proceedings.
If it is the good matter.
Good,
is-
then he need not have to discuss. And he does not have the jurisdiction to discuss.
Yes,
And decide the matter on the basis of such evidence.
Yes.
What he has decided on the basis of the evidence laid before him.
laid before him, and that he cannot do, madam.
That should not have been
Yes,
done.
Done.
Yes, what do you say about this?
Lordship, I have to find some judgment regarding the matter.
What judgment?
In case there is some point in my favor, Lordship.
What judgment? These are the judgment. This has been upheld by the constitution up till date.
Lordship, I leave it to your Lordship.
There is nothing. We are not disturbing anybody. We will be, Miss MS Bhattacharya will be remanding to deal with the manner it should have been dealt.
With a time limit, madam.
Like the other one,
Yes,
because every record is before the trial court,
trial.
because all this inquiry report was there.
Yes.
He should have discussed this.
There is no discussion at all, madam.
Then he should have discussed the evidence given by these two witnesses, Zitian Kurmi
Yes,
and Bonsidhar Kurmi,
yes,
and the workman given
Yes.
before the
yes. Labor.
inquiry officer.
Inquiry officer.
Plus, there was a presenting officer.
Yes,
This
No
word is
discussion.
silent.
yes. There is no discussion.
In the present petition. Under Article 226 of the Constitution of India is prepared by the workmen of Messrs. Kumtai Please take your seat, Mr.
Pita, sir.
From the COMTI, Kumtai PhD. To a sale an award date
31/12/20.
31
2010.
31/12/2010 passed by the Learned Labor Court, Dibrugarh, in reference case number 10/2007. By the award dated 31/12/2010, the Learned Labor Court, Dibrugarh, within bracket the Labor Court for short, has decided the two issues framed by it in favor of the management of Messrs. Kumtai Tea Estate and by deciding the two issues against the petitioner workman, the Learned Labor Court has held that the management of Messrs. Kumtai Tea Estate was justified in dismissing the service of the petitioner as workman WEF 12/4/2005 and that the petitioner workman would not be entitled to reinstatement or any other relief in lieu thereof. Before the Learned Labor Court, the petitioner workman was represented by the secretary, Assam Shah চাহ কৰ্মচাৰী সংঘ, কমা গোৱালপাৰা গোলাঘাট circle, comma a registered trade union of workmen. Para. It is not in dispute that the petitioner, was a workman in Messrs. Kumtai Tea Estate, situate in the district of Dibrugarh, and an unit of Messrs. Badulipar Limited.
District of Golaghat.
Golaghat? Okay, Golaghat. Good stuff. The genesis of the dispute is traceable to a show cause notice dated 27/2004, issued by the senior manager Messrs. Kumtai Tea Estate against Ratul Bora, BURAH, and 2 Sri Simanto Kotoki, IE, store clerk, IE, the petitioner. in the so-called notice, comma, it was stated that it had come to a notice of the management of Messrs. Comtite Tea Estate that its store under the control of the two notices was not being properly maintained. And there were many items in the store which did not agree with the store ledgers. Full stop. The so-called notice had further mentioned that there was no good system of receipt and issue of items, and their accountability was in a mess. Full stop. A reference was made to a letter dated 16/7/2004 from the head office, issued from the head office to mention that there were discrepancies in chemicals. Full stop. Reference was also made to an internal audit report dated 28/6/2004 to state that a difference of 31,356 liters of high-speed diesel HSD consumption was detected by serving the said to by serving the so-called notice, comma, the notices were asked to explain as to why such discrepancies occurred in the store ledgers, which was store in the store items, stores ledger, comma, which were under their control. We'll resume after 2 minutes. The notices were further served a letter on 27/8/2004, wherein it was informed that on cross-checking of the store's ledger for the high-speed diesel HSD between the period from 1/4/2004 to 31/7/2004, comma, a shortage of 5,900 liters of HSD worth rupees 1,24,432 was found, and the notices were requested to clarify the position as to how such discrepancy had occurred. Full stop. In it. It got it. Line. It line থাকক তাৰ আগত. The notices, the two notices were served a letter on 14/8/2018. Informing that on cross-checking of the store's ledger by the management, discrepancies on issuance of high-speed diesel on without requisition on various dates, indicated therein, were found, and the notices were directed to clarify the position on or before 18/8/2004. তাৰপিছত এইখন on receipt of the US store clerk, right?
Okay.
On receipt of the letter dated 14/8/2004, the petitioner replied on writing on 18/8/2004, তাৰপিছত এখন 27/8. What is the charge sheet?
Annexure 3.
It was on 29/11/2004. The management served a charge sheet to the petitioner and Sri Ratul Bora wherein it was stated that on cross-checking of the store's ledger of the allegation of the round 142 exhibit H. Store ledger by the management, it was detected that the petitioner with a malified the intention of committing theft had dishonestly misappropriated the company's property for personal gain by indulging into alleged offences like misappropriation of high-speed diesel to the extent of 30,691 liters, worth rupees 6,25,880 between the period from 1/4/2003 to 31/7/2004. And indulged in fraudulent activities by manipulating the store's ledger and the requisition slips, etc. Full stop. It was mentioned that if the alleged offences were proved, then the same would be an offence under the standing orders in force in Messrs. Comtite Tea Estate. Full stop. The petitioner was called upon to explain as to why disciplinary action should not be taken against him. And the petitioner was asked to submit his explanation within a stipulated time period. Full stop. In response to the charge sheet, the petitioner submitted his explanation on 7/2/2004. Full stop. The management had thereafter issued a letter, issued a communication dated 14/12/2004 to the petitioner informing that his explanation provided in the letter dated 7/12/2004 in reply to the charge sheet dated 29/11/2004 was found not satisfactory. Full stop. The petitioner was informed that the management had decided to hold an inquiry into the charges level against the petitioner. And in the said inquiry, he would be given full opportunity to conduct his defense and to examine his witnesses and to cross-examine the witnesses of the management. Full stop. On 20/12/2004, the petitioner replied to the communication dated, replied in writing to the communication dated 14/12/2004. On 6/1/2005, the senior manager, Messrs. Comtite Tea Estate, served a notice upon the petitioner. Serve a notice of event upon the petitioner, informing him that One, Mr. N Singh, comma, superintendent manager, comma, Messrs. Duklinia, Duklingia, Estate, had been appointed as the inquiry officer and the petitioner was directed to attend the inquiry before the state inquiry officer. It was mentioned there that in the inquiry, the petitioner will be given full opportunity to conduct his defense and to examine his witnesses and to cross-examine the witnesses of the management. The petitioner was requested to give the names of the employees, comma, if any, comma, whom he would like to examine as witnesses so that arrangement could be made for their presence at the inquiry. It was further informed that if the petitioner would wish to examine as a witness anyone not employed in Messrs. Komtai Tea Estate, comma, he should arrange for their attendance in the inquiry. Full stop. It transfers that domestic inquiry proceedings were conducted by the appointed inquiry officer on a number of dates, including 29/1/2005, wherein the domestic inquiry proceedings on 29/1/2005 was shown to be attended by the delinquent workman, i.e. the petitioner, comma, a presenting officer appointed by the management of Messrs. Komtai Tea Estate and 2 independent observers. Full stop. It further transfers from the records of the reference case number 10/2007. Requisition, comma, requisition by order dated 2/8/2013, comma, further transfers, no, from the records of, comma, that the management side through the presenting officer exhibited a number of documents and to bring home the allegations, bring home the charges against the delinquent workmen examine two witnesses as management witnesses. EIZ1 Jiten Kurmi, Roman 1. Jiten Kurmi and 2 Bonsi, Bonchi or Dhar Kurmi, and said two management witnesses MW1 and MW2, and the said two management witnesses were cross-examined by the delinquent workmen. Full stop. It further transfers from the case records that the delinquent workman had also adduced his evidence in the domestic inquiry proceedings. Full stop. After a recording of the depositions of the management witnesses and the delinquent workmen, the inquiry officer submitted an inquiry report wherein he held that both the charges brought against the delinquent workmen were found to be true. Inquiry officer on 15/2/2005. Both the charges brought against him provide the charge sheet dated 29/11/2000. Full stop. Para. Uh, no. Full stop. No. On receipt of the inquiry report, the senior managers, Messrs. Comtai TST, had issued a letter to the delinquent workmen, i.e. the petition, on 1/3/2005, stating inter alia that as the inquiry officer had recorded his findings to the effect that the charges leveled against him were proved, the petitioner will be given a personal hearing to submit further statements, if any, and the petitioner was thereby directed to appear before the senior manager, Messrs. Comtai Tea Estate, on 4/3/2005 with the observation that in the event the petitioner fail to attend the personal hearing, it would be presumed that he had nothing further to add, and final orders would be passed on the basis of the inquiry report. Finally, on 12/4/2005, the petitioner was informed by the communication of event date that the petitioner was found guilty of gross misconduct in the domestic inquiry proceedings, and a personal hearing was given on 4/3/2005. Full stop. As the statement of the petitioner was given in the said personal hearing was not found satisfactory to disprove the charges, the management of Messrs. Komtai Tea Estate had decided that the petitioner should be dismissed from the services, as the past records of the petitioner did not reflect any extenuating circumstances to take a lenient view. By the communication dated 12/4/2005, which was, in a sense, an order of dismissal, the petitioner was informed that he had been dismissed from the services of the company WEF 12/4/2005. Full stop. Para. Being aggrieved by the said decision taken by the management of Messrs. Komtai Tea Estate to dismiss the service of the workmen, the trade union, Messrs. Assam Sah Mazdoor, Assam Sah Kormosari, Sah Kormosari, Pongho, Gulaghat Circle, through its secretary, raise an industrial dispute in respect of the matter of dismissal of the workman, i.e. the petitioner. Right? Para. The government of Assam in the labor, Roman and employment department referred the dispute refer the industrial dispute to the labor code by way of a reference under clause small c of subsection 1 of section 10 of the Industrial Disputes Act 1947, as amended, provide a notification bearing number dated 17/7/2007. Post of the contents of the notification read as under. And put it. Is 20, say 20, it would. Where after receipt of the notification, the learned labor code register the same as reference case number 10 of 2007. Full stop. After registration of reference case number 10/2007, the learned labor code by an order dated 3/8/2007, issued notices to both the sides, asking them to file their respective written statement along with all other documents on which they intended to rely. Full stop. On receipt of notices from the learned labor court, both the sides entered their appearances before the learned labor court. It is noticed from the records of reference case number so and so, the management side the workman side submitted its written statement and documents on 13/2/2008. Full stop. The management side had thereafter filed its written statement and documents on 18/2/2008. On 13/3/2008, the management side made a prayer before the learned labor court to allow filing of additional written statement and documents. And an additional written statement was filed by the management side on 23/4/2008. So 19/5/2008. Full stop. Subsequent thereto, the workman side filed an additional written statement on 11/6/2008. On 16/9/2009, the management side, by filing a petition, made a prayer to I made a prayer for permission to file an additional written statement. Full stop. The London Labour Court, after hearing both the sides, allowed the prayer of the management side to file the additional written statement. In the interest of justice. Full stop. Para. In the proceedings before the London Labour Court, the workmen adduced his evidence on 4/6 SWW1. On 4/6/2010. And he was also cross-examined by the management side. Full stop. After cross-examination, the workman was also re-examined. Full stop. The management side adduced testimonies of two witnesses, VIJ, one Othir Chandra Roy, MW1 as MW1 within bracket, examined and cross-examined on 21/10/2010, and MW and one and Bhargav Bhushan
Power.
Kora,
BAWA. Power.
Bhargav Bhushan
BAWA.
BAWA Bawa
Bharat
Bawa.
Bhushan Bawa.
Bawa as a FW2
Is
within bracket,
Bharat
examined and cross-examined on 21/10/2010.
Bhushan.
Bharat Bhushan. Not Bhargav, it's Bharat Bhushan.
It is corrected, my lord, as Bharat.
Bharat BHARAT Bharat
Bhushan Babu.
Bhushan. আৰু আগৰটো অধীৰ চন্দ্ৰ ৰয় ROY. এইটোৰ আগত এইখিনিতে W1, WW1, W1, account. In the written statements, stroke additional written statement, comma, the workman, WORKMAN, MEN, postopius. Workman's side had contended that it was the factory engineer stroke deputy manager, comma, who received the oil vouchers and was responsible, were responsible for loading and unloading of concerned oil tankers and had the responsibility to supervise the factory fuel tanks of high-speed diesel. Full stop. It was contended that the petitioner, as the stores clerk, was not at all involved in any alleged act of misappropriation. Full stop. It was further contended that the HSD oil preserver tank was within well-fenced boundary and there used to be tight security. Full stop. As such, comma, the allegation of misappropriation by the workmen from such HSD oil preserver tank was baseless and misconceived. Full stop. The requisition slips for HSD were mainly issued by the head fitter and signed by the factory manager. And the duty of the store clerk was only to issue the HSD or any other materials to the bearer on receipt of proper requisition slips. In view of responsible supervising officials, like in view of presence of responsible supervising officials like factory manager and senior storekeeper, comma, the petitioner as the store clerk could not have been made responsible for any alleged misappropriation of HSD or other commodities from the store. In the additional written statement, comma, the workman's side had sought to point out that the senior storekeeper, who was the sole in charge of the store, was not implicated. And the factory manager were not implicated. Full stop. Subpara. In the written statement filed on 18/2/2008, the management side had taken the stand that the domestic inquiry proceedings was held in conformity with the principles of natural justice and fair play. Full stop. The delinquent workmen attended the domestic inquiry proceedings without any objection, and the domestic inquiry proceedings were held in presence of independent observers. Full stop. The inquiry officer recorded his findings in the inquiry report on the basis of the available evidence, records, exhibits, etc., as provided for by the presenting officer and other witnesses, including the delinquent workman who was present throughout the course of the domestic inquiry proceedings. Full stop. As the inquiry officer recorded findings that the charges leveled against the delinquent workman stood proved beyond doubt, the management had come to the conclusion that the delinquent workman was guilty of gross misconduct. Accordingly, the management side, after giving an opportunity of partial hearing to the delinquent workman on 4/3/2005, took the decision to dismiss him from service WUF 12/4/2005 by serving him the order of dismissal dated 12/4/2005. In the additional written statement filed on 16/11/2009, the management side took the plea that the dismissal of the workman from service was fully justified and he was not entitled to any reinstatement or any other relief. Full stop. The management side had further taken a stand that they intend to rely on the domestic inquiry held by it first, and if the learned labor court holds that the domestic inquiry was not in order and violative of the principles of natural justice, they would lead evidence to prove their case on merits. Full stop. It further, it was further averred that since it was the workman who initiated the proceedings for adjudication on the ground that his dismissal was illegal, it would be the workman who must lead evidence to prove his case. It would be the workman who must lead evidence first to prove his case. Cross-examine. After submission of the written statements and additional written statements by both the sides, the learned labor court had proceeded to record the depositions of the witnesses from the workman's side at first. Reduce the The learned labor court pronounced its award on 31/12/2010. In reference case number on 31/12/2010, recording that before the learned labor court had framed two issues as under issue number 1. Whether the domestic inquiry proceedings held by the management was a valid one, and 2, no, same thing. The learned labor court pronounced its award in reference case number so on 31/12/2010, recording that the management of Messrs. Comtai Tea Estate was justified in dismissing the service of the petitioner workman with effect from 12/4/2005 in view of the decision on the first issue in the first stated manner, comma, the learned labor court had observed that the petitioner workman was not entitled to reinstatement with full back wages or any other relief in lieu thereof. Full stop. By holding so, comma, the labor court decided the issue number 2 had also decided the issue number 2 against the petitioner workman. Full stop. Para aggrieved by and dissatisfied with the award dated 31/12/2010 passed by the learned labor court on so and so in reference case number so and so, the workman side through the workman side has preferred the instant writ petition challenging the same. Full stop. Okay, we'll continue at Mr. Sharma.
Mr. Das.
You go through that Labor Code in justification of its decision under consideration by such court is not a statutory right. Suppose that the procedure has been laid down by the Honorable Supreme Court of India to avoid delay and multiplicity of proceedings in the disposal of disputes between the management and the workmen. Full stop. After receipt of the reference by the learned labor court, through the notification, bearing number so and so dated 17/7/2007, when notices were issued by the learned labor court to the parties, right, order dated 3/2007, the management side had filed its written statement and additional written statements on and the workman side had submitted its written statement and additional written statement on so and so respectively. Full stop. In the additional written statement filed by the management side on 16/11/2009, a specific stand was taken that they intended to rely on the domestic inquiry held by them first, and if after its consideration, the learned labor court would come to a finding that the domestic inquiry proceedings was not in order and was violative of the principles of natural justice, they would intend to lead evidence to prove their case. Full stop. As it is noticed, it is discernible from the order dated 16/11/2009, passed in reference case number so and so. The learned labor court had allowed the management side to file its additional written statement where such a plea was taken. Full stop. The order dated 16/11/1999 has further reflected that it was after hearing both the sides, the learned labor court had allowed the management side to file the additional written statement in the interest of justice, wherein such plea was taken. In the Constitution bench judgment, in of Lakshmi Devamma Supra, the history as to why such procedure is required to be followed in a case of dismissal or discharge of a workman has been traced. In the face of such established principle of law, a perusal of the award dated 31/12/2010 goes to show that it was submitted on behalf of the workmen side that the domestic inquiry proceedings was not conducted by the management by by duly adhering to the principle of natural justice. In that puस्तक, a further plea was taken that non-supply of the inquiry report prior to the order of dismissal dated 4/2005 had vitiated the domestic inquiry proceedings. Full stop. Insofar as such contentions are concerned, the learned labor court had observed that the observed that non-supply of the inquiry report would not ipso facto vitiate the order of punishment in the absence of any prejudice to the delinquent employee, and had gone on to observe that in the domestic inquiry proceedings held against the petitioner workman leading to the order of dismissal dated 12/4/2005, the petitioner workman had failed to show any prejudice. Full stop. But what is noticeable from the impunity award of the learned labor court is that to arrive at the findings in respect of the two issues framed by the notification, it had proceeded to discuss the evidence laid before it by the management side after the reference, instead of to examine the validity, legality and validity, validity and propriety of the domestic inquiry proceedings. Full stop. It was after discussing the evidence of the two management witnesses and the documents exhibited by them, the learned labor court had reached the finding on the first issue to the effect that the domestic inquiry proceedings was a valid one And delinquent workman was given opportunity of being heard before being dismissed from his service. The Labour Court had further observed that the delinquent workman did not suffer any prejudice because of non-supply of the inquiry report prior to the order of dismissal, and the management of Messrs. Komtai Tea Estate was justified in dismissing the services of the delinquent workman, resulting in non-entitlement of any relief, including the relief of reinstatement. Full stop. The Impune Award on perusal of the Impune Award, it is found that there is no discussion about the proceedings held by the management in the domestic inquiry. Full stop. There was no discussion about the documentary evidence presented by the presenting officer before the inquiry officer appointed to conduct the domestic inquiry. There was also no discussion as to what evidence were laid by the two management witnesses, one Jiten Kurmi, two so-and-so, adduced by the two management witnesses, Jiten Kurmi and so-and-so, Arota MW1 and MW2. In the said domestic inquiry proceedings, full stop. There was no discussion. There was also no discussion as to whether the findings recorded by the inquiry officer in the inquiry report were on the two charges, on the two charges leveled against the delinquent workman could be termed as justified or justified on the basis of the evidence laid in the course of the domestic inquiry proceedings or not. Full stop. As has been observed in Firestone Supra. it is open for the labor court stroke industrial tribunal, after incorporation of section 11A in the Industrial Disputes Act, to consider the matter on the evidence to reach a satisfaction. About the guilt or otherwise of the delinquent workman concerned, by considering the evidence and to come to a conclusion one way or the other. And it has the authority, and it can differ from that finding in a proper case. The labor court stroke industrial tribunal may also hold that the punishment imposed on the delinquent workman is not justified because the misconduct alleged and found proved is such that it does not warrant dismissal or discharge. Full stop. Para. The case in hand is one where the depositions of two management witnesses and the deposition of the delinquent workman were recorded by the inquiry officer during the course of the domestic inquiry proceedings, and these depositions were discussed in a domestic inquiry report dated 15/2/2005. Full stop. Therefore, both the depositions of the management witnesses and the workman witness and a domestic inquiry report dated 15/2/2005 were available before the learned labor court. Full stop. In such obtaining fact situation, the learned labor court ought to have, in the first instance, proceeded to consider as to whether the domestic inquiry proceedings conducted by the management side was valid and proper or not. In view of the categorical stand taken by the management side in its additional written statement that they intend to rely on the domestic inquiry held by them first, instead of deciding the validity and propriety of the legality, validity and propriety of the domestic inquiry proceedings on the basis of the evidence laid by the management through the two management witnesses before it, after the reference. If after such consideration of the materials in the domestic inquiry proceedings, the learned labor court reaches a satisfaction that such domestic inquiry proceedings had been held properly and validly and in conformity with the principles of natural justice by affording adequate opportunity of being heard, the question of considering the evidence adduced before it on merits would not have survived, as it is settled that it is only when the labor court holds that the domestic inquiry proceedings conducted by the management was not properly and validly held, it can assume and derive jurisdiction to deal with the merits of the dispute before it by discussing the evidence adduced before it after the reference under section 10 of the Industrial Disputes Act. Para. Now, it is settled that a writ of certiorari is issued in exercise of the extraordinary jurisdiction under Article 226 of the Constitution of India. First off, the writ jurisdiction extends to cases where orders are passed by courts or tribunals or authorities in excess of their jurisdiction, or as a result of their refusal to exercise jurisdiction vested in them, or if such courts or tribunals or authorities act illegally or improperly in exercise of their jurisdiction, or fails to exercise jurisdiction, a jurisdiction which is vested in them. Full stop. A writ of certiorari, a writ in the nature of such, under Article 226 of the Constitution of India is issued for correcting errors of jurisdiction, that is, when a subordinate court or tribunal or authority is found to have acted in disregard of the established disregard of law or established rules of procedure, thereby, occasioning failure of justice. Para. From the It has been held. It has been observed in by the in ML Singla versus Punjab National Bank and another, reported in 2018 SSC 21. That insofar as the scope of interference under the certiorari jurisdiction in certiorari jurisdiction under Article 226 of the Constitution of India is concerned, it has been held in so and so, that a proper approach for the High Court should be to identify the jurisdictional errors, if any, committed by the Labour Court stroke Industrial Tribunal, clarify the law and remand the matter for decision afresh, rather than going into the merits of the case. Full stop. From the discussion made above, in respect of the fact situation obtaining in the case in hand and for the regions assigned herein, it has clearly emerged that the Learned Labour Court, in the process of adjudicating the reference wide award dated 31/12/2010, had confined itself in considering only the evidence laid by both the sides before it after the reference, without first reaching any findings whatsoever as regards the legality, validity, and propriety of the domestic inquiry proceedings held by the management side, culminating in the order of dismissal dated 12/4/2005, culminating in the inquiry report dated so and so, and the order of dismissal dated 12/4/2005. Full stop. It has thus clearly emerged that the Learned Labour Court has lost sight of the position of law, that it is only after it reaches a satisfaction to the effect that the domestic inquiry proceedings conducted by the management leading to the inquiry report and the dismissal of the delinquent workmen was not valid and proper, it can assume and derive jurisdiction to proceed and to deal with the evidence laid before it for adjudication of the industrial dispute referred to it by the reference. Thus, this court is of the clear view that the award dated 31/12/2010 is not sustainable in law, and the same is liable to be set aside and quashed. It is accordingly set aside and quashed. With the setting aside and quashing of the impugn order award dated 31/12/2010, in the aforestated manner, the matter stands remitted to the Learned Labour Court, Dibrugarh, to decide the reference comma, that is reference case number so and so, FRES in conformity with the principles required to be followed in a reference of such nature which consists of which consists of two stages, which consists of two stages of consideration of the dispute. It is accordingly remitted for the purpose of facilitating an expeditious consideration of the reference, comma, both the contesting sides who are present before this court, comma, are directed to appear before the learned labor court Dibrugarh on today is October, November calendar. Tenth of November, 10/11/2023, by presenting a copy of this order, Post of Law Learned Council representing the two contesting sides have fairly submitted that for the purpose of appearances on 10/11/2023, the parties would not insist for issuance of notices by the learned labor court Dibrugarh. It is expected that on such appearance of the parties before it on 10/11/2023, the learned labor court, comma, Dibrugarh would proceed with the matter to decide the reference FRES in an expeditious manner, comma, preferably within a period of 3 months from the date of such appearance. Full stop. Para, it is made clear that the observations made in this order are made only for the purpose of examining the legality and validity of the award dated so-and-so, passed in reference case number so-and-so, and the same shall not be construed as observations on merits in respect of the domestic inquiry proceedings held by the management side leading to the inquiry report dated so-and-so and the order of dismissal dated so-and-so. And the learned labor court Dibrugarh shall proceed with the matter on its own merits and in accordance with law. That'll do. Anything? Yes. Maybe the industrial tribunal may be having what to do, then you have to do something else. You have to take recourse to some other proceeding. We cannot decide. If jurisdiction is vested in some other tribunal, say Jorhat, we can do so. If it is there in your official order. Get the information, file an I. If jurisdiction is vested in some other court, then we can pass the order that since labor court Dibrugarh is not functioning as at present, get the confirmed news. LCRs to be sent back forthwith. এইখিনি ৰেকৰ্ডটো ভালকে থৈ দিব দেই। LCRটো ভালকে নাজানো, ৰছীডালো গাঁঠি থব লাগিব। ভালকে থৈ দিব। এইখন আপোনাৰ ন? এইখন গাঁৱৰ নেকি? বৰাই চামি। Yes.
Item number 3.
এইখন কি? এইবোৰ লৈ যাব। এইবোৰ লৈ যাওক। Yes. Rules, Mr. Setia?
Yes, my lord. Rule 8, my lord. Rule 8 is clear, my lord.
The industry rule on that. Yes, Mr. Gogoi and Mr. Chetia.
My brother will appear.
How do you defend this order?
Yes, my lord. And it rule provides for, my lord.
Rule?
Rule 8, my
I'm
lord.
job.
Central Lake Closely.
Huh? Central
Central
Which one? Payment?
Payment of wage procedure rules, my lord. 1937.
Payment of wages rules. Act. Yes, rule.
Rule 8, my lord. Rule 8, my lord.
And what about the state rules? Same?
Rule 9, yes, same.
So you have kept this writ petition pending for 10 years.
Yes, my lord.
Yes, Mr. Gogoi. Filing objections. Huh? Have you filed objections?
We have filed an
Affidavit in opposition. By whom? Respond number?
Respond number 1, my lord.
4, 5, 4,
1 minute, 1 minute. Because
Respond number
affidavits are filed means I have to deal with them. Affidavit in opposition. Filed by
Respond number 1, my lord.
respond number 3 also. Respond number 1.
Yes.
Okay, Deputy Secretary.
Yes, my lord.
What does it say?
Each only says that, my lord, order was communicated to them, my lord.
React to
Fixed, my lord.
so requisition notice dated 14/3 was issued. Okay, 1 minute, because the stance. Let us see the proceeding, Mr. Let us read the order, because some contentions Mr. Setia and Gogoi has raised. Let us read the order.
Case 24.
Yes, read.
The instant case is filed by Mr. Sovinto, ex-employee of Sovinto, through Mr. Sovinto, who was duly authorized by Sovinto on Sovinto in respect of claim arising from non-payment of the outstanding dues and other billing.
Who? Bhanu Gwala. Who is Bhanu Gwala?
Respondent number 4. The workman. Under respondent number 5.
Bhanu Gwala. Okay. Ex-employee.
Madam.
Okay, Zatinga Valley Tea Estate. Through Dheeraj Das. Okay, Sah Karmasari Sangha.
Yes.
Silsor. Duly authorized by Bhanu Gwala on 11/12. in respect of a claim arising out of non-payment of outstanding due and other benefits to Bhanugola by the management of Chattinga Swings under the provisions of the case was registered as. What is the provision here?
Section 15, subsection.
Hmm? Section 15.
My lord.
Your case is non-payment.
Yes, ma'am.
Huh?
Madam.
Sorry, respond number 4. Who is respond number 4?
He's not appearing, my lord.
Served or not?
Yes, ma'am.
Notice
If
that,
it
my
is
lord,
been-
name has been reflected, my lord. Council's name has been reflected.
As their piece and name reflected.
As they patient. Okay.
They have also filed their affidavit.
Okay. 1 minute. Into what was the prayer made in the claim petition? Non-payment of outstanding wages, dues.
The prevailing allowance putting VDA and medical.
Mhm. Where is the claim? Anything available? Reference PWPS.
That is the copy of the petition.
Hmm?
Copy of the petition.
Okay. Part of the repetition or not?
No, my.
No.
Okay, let us read the order again, 24, paragraph 2 onwards. On receipt of the claim petition. Read.
On receipt of the claim petition, notice was served upon the opposite party for filing of WH or any objection and fixed the date of 2/4/2012, but no response. Again, the next date was fixed on 4/5/12, but no response. Thereafter, date after date were fixed. At all dates, the opposite party failed to respond. In the meantime, the petitioner filed affidavit in chief on 23/11/12. Despite the authority further offered time to give scope to the OP for hearing, but again they failed. Last time was given fixing date on 6/10/12, but no steps were taken by the OP in the last time given to. The next date was for final date on 29/4/30. As the OP continued to remain absent without any information, the authority therefore took ex parte decision against OP. On perusal of the claim petition and the affidavit in chief filed by the petitioner and the proceedings of the case record, it is learned that the claimant representative Mr. So-and-so was duly authorized to represent the first party. The claimant Bhanugola was working initially in the capacity of Peter in so-and-so, and thereafter he was transferred to Jatinga Valley State on so-and-so, and took voluntary retirement from his service on L ground, which was accepted by the manager. But there was outstanding dues against Mr. Bhanugola to be paid by the OP manager Jatinga Valley. The claimant approached the manager before filing of this case, but but no no response. So the claimant has to file this claim petition before the authority. Despite several chances were given to the OP, but they failed to reply in all days. Therefore, the authority took ex parte petition against the OP. The authority presumed that the OP was not interested to contest the case, hence did not make any appearance and filed any objection before the court on any day. The claim filed under the provisions of payment of wages is therefore treated to be true and genuine. The claimant will be entitled to get all his entitlement due benefits during his service. The OP manager, judging that validity state is liable to pay the following claimant. Further, the claimant also prays for compensation of 10 times and cost of proceeding. From the above, the proceeding of the case record and the decision of the authority is to issue direction for payment to the OP. The OP is also liable to pay compensation and the authority imposed 2 times compensation with the some money to the OP. The authority therefore directed the manager judging the validity state OP to deposit the sum amount of rupees so and so along with 2 times compensation to the undersigned within 45 days from the issue of issue. The computed amount therefore payable is so and so only excluding cost of proceeding.
So what did you prefer thereafter?
Thereafter, I prepared an application under Order 9 Rule 30, page 26. On the ground that I didn't receive any notice.
As per record, I hope this would be answered. Yes, 29, what's wrong? He has rightly observed Order 9 Rule 13 is not available.
At that time, my lord, the desk provision has been put at my lord. At that time of filing of the application, my lord, that provision had been.
So in one sense, he's got wrong. Because you have quoted the wrong provision, Order 9 Rule 13.
Yes, ma'am.
So you have quoted the wrong provision, he has passed the right order.
Under that provision, he have no power, my lord.
But my lord, only the fact is that the
And you have come also with this petition with the same. Now, which I have indicated earlier that there is a rule, there is provision. So what you have pleaded in this petition? Order 9 Rule 13 is applicable.
no, my lord.
Huh? Okay, what are the stands taken? Let us see, because affidavit of service. Response number 3. When the notice was served. Earlier notices were also sent.
Earlier notices were sent, but those were not received by the petition. I could only-
Notices dated so and so. 14/3/2012. (23/4/2013). The opponent has no. What we are sent by registered. So repeated absentee, according to the
Yes, my lord.
state respondents,
My lord.
that repeated absentee.
Only thing is that at para 4, my lord, they have not offered any comment as to the,
In para
Para
four,
four
I said that-
denied.
Yes, my lord.
but no comment on denied of,
Regarding
A
denial part, my
non-receipt.
lord, no
that
comment.
has been denied by me.
But it is not also your case. It is not also your case in order 9 rule 13 petition that you received or not received. Because order copy you have received, right? This impugn order copy you have received.
Yes, ma'am. The-
And there were mentioned about sending of earlier notices. In the in the body of the order. That you were also silent about that.
Yes.
That is why they are saying that you were repeated absentee.
My lord, that,
You have not said anything about those notices.
paragraph 2, ma'am. Page 20,
Paragraph 2,
page 26, my lord, that order my petition.
page 26.
Had the OP had no, the OP had no knowledge of the date of hearing.
Fixed on so and so.
Came to learn on 20. Had the OP been notified earlier prior to,
When the notice was delivered to him by post, had the earlier prior to,
so the 23/4/21, 2011 notice that has been referred to was with regard to fixing the date on 29.
now private respondent. So according to private respondent, you were deliberate. There was deliberate omission on your part. Intentionally avoided. Rightly rejected. I picked 20%. Yes,
Yes, my lord.
because some contentions have been raised in the counter affidavit of respondent number 4. Though he is not absent, he is absent. So according to the private respondent, you should have preferred an appeal. Under section 70. Okay. And said notice were served a number of times, sent. Because I did the instant the present litigation. Under Article 226 of the Constitution of India. is preferred against selling an order dated 16/12/2013 passed by the Assistant Labor Commissioner within bracket the respondent number 2 as an authority A2 capital
Respondent number 3.
3
Madam.
respondent number 3 as an authority under the Payment of Wages Act 1936 in case number P full stop W full stop 6 stroke 2011. Assistant Labor Commissioner, comma, Kachar. Kachar Silchar. Full stop. By the order dated 16/12/2013, comma, the respondent number 3, comma, that is, comma, the authority under the Payment of Wages Act has rejected a petition filed by the petitioners seeking filed by the petitioners under Order 9, Rule 13 of the Code of Civil Procedure 1908 as amended. Seeking setting aside of an order dated 2/5/2013 passed by the said authority in case number PW 06/2011. The a brief narration of the background events leading to the passing of the order dated 16/12/2013 appears necessary at the inception. The petition number 1 is a company incorporated under the Companies Act 1956. And the petition number 2 is an unit of the petition number 1 company. Full stop. The petition number 2 comma Messrs. Zatinga Valley Tea Estate runs a tea estate by the same name and style in Damchera, DAMCHERRA, in the district of Kachar, Assam. Fair enough. The respondent number 4. Claiming to be a workman employed in Messrs Jatinga Valley Tea Estate. Filed a petition. Filed an application. Claiming file an application before the respondent number 3.
Right.
3. Who is an authority. Under section 15 of the Payment of Wages Act 1936. To decide inter alia a claim regarding non-payment of wages or delayed payment of wages. Claiming that the employer, Messrs Jatinga Valley Tea Estate, did not make payment of salary and other benefits to him since other benefits like VDA. What is VDA? Variable dearness allowance or what? VDA within bracket traveling allowance. TA, fuel charges, medical benefits, etc. for the periods indicated therein. Full stop. The respondent number 4 had thereby, claimed that total amount payable towards delayed stroke non-payment of wages and other benefits was rupees 40,520. On receipt of the said application from the respondent number 4, the respondent number 3 registered the same as case number PW06 2011. Full stop. Para. In the proceedings before the authority under the Payment of Wages Act, within bracket the respondent number 3, the workman was represented. The respondent number 4 workman, within bracket X, was represented by Messrs. Borak Valley Shah, Kormosari Hongho, Silchar, through its Vice President, on being duly authorized by the respondent number 4 dash workman within bracket X on 11/12/2011. Full stop. The authority under the Payment of Wages Act within bracket respondent number 3 decided to proceed with the same application, and the claim application was finally decided by passing an order dated 2/5/2023. Wherever it was directed wherein it was observed that the claim filed by the respondent number 4 dash workman X under the provisions of the Payment of Wages Act were to be treated as true and genuine, and as such, the respondent number 4 dash workman X as the claimant would be entitled to get all his entitlement as due benefits full stop. By holding so, the authority under the Payment of Wages Act directed the manager, Messrs. Jatinga Valley Tea Estate to pay an amount of rupees, pay a sum of rupees 1,21,560, including the cost of the proceedings, within a period of 45 days from the date of issuance of the said order. Full stop. The sum of rupees 1,21,560 comprised of two parts, firstly, an amount of rupees, a sum of rupees 4,520,000 towards non-payment stock, delayed payment of wages and other benefits to the respondent number 4 dash workman X and a sum, secondly, comma, a sum of rupees 1,21,560 minus করে দিলে 40,520 যেটো হ'ব কিমান হ'ব ক্যালকুলেটর which was twice, which was 2 times the sum awarded as non-payment stroke, delayed payment of wages and other benefits as compensation. Right? 1,21,560
The difference would be 81.
minus 4,520. Sorry, 4,520. 40,520. 80,000.
81,000.
81,040. 81,040. Full stop. The order dated 2/5/2013 was passed ex parte by the authority under the Payment of Wages Act. In view of absence of the employer of the respondent number 4 as Workman X, comma Messrs. Datinga Valley Tea Estate. Post. Para. From the contents of the order dated 2/5/2023, comma, which is annexed as Annex Roman 4 to the state petition, comma, it is noticed, it can be noticed that the authority under the Payment of Wages Act had observed that after registration of the claim application, comma, notice was served upon the employer, comma, Messrs. Datinga Valley Tea Estate for filing of written statements or objection, comma, if any, and a date was fixed for their appearance and or filing of written statements to objection on 2/4/2012. To stop. As no response was received from the employer pursuant to the notice, said notice, comma, the authority fixed the next date on 4/5/2012. To stop. The authority had observed that on 4/5/2012 also, comma, no appearance was made on behalf of the employer. Full stop. The authority had further observed that a number of dates were fixed thereafter for appearance of the employer, but the employer was found unrepresented on those occasions also. Full stop. The respondent number 4, that's Workman X as the claimant, had, comma, in the meantime, filed its affidavit on 23/11/2012 in support of its claim. Full stop. The authority had observed that last opportunity was given to the employer by fixing a date for its representation, by fixing a date on 6/10/2012, but on that occasion also, the employer was found unrepresented. Full stop. Accordingly, another date, 29/4/2013 as final date. Another date, 29 was fixed. Accordingly, sorry. The authority had thereafter, posted the case on 29/4/2013 as the final date for appearance of the employer. When on 29/4/2013 also, the employer remained absent without any information. The authority had thereafter taken the decision to proceed ex parte against the employer of the respondent number 4-Workman X. Full stop. After deciding to proceed ex parte against the employer, Messrs. Chatinga Valley Tea Estate, the authority dealt with the claim, had proceeded to deal with the claim of the respondent number 4-K, respondent number 4-Workman X, on its merits, and had recorded a finding that the amount claimed by the respondent number 4-Workman under the provisions of the Payment of Wages Act was found to be just. And to stop with such findings, the order dated 2/5/2013 came to be passed by the authority with the direction to the employer, Messrs. So and so, to make a payment of a sum of rupees 1,21,560 in the aforestated manner within the period of 45 days therefrom. Full stop. It was after passing of the order dated 2/5/2013 ex parte against the employer, Messrs. So and so, a petition purportedly under Order Rule 9. Order 9, Rule 13 of the Code of Civil Procedure, RW, Section 151, CPC, I'm going to say equally, came to be prepared before the authority seeking setting aside of the award dated 2/5/2013 passed by the authority under the Payment of Wages Act. In the said petition, filed on which date? 22/5/2013. The employer. The petitioner's side. I, the employer, had averred that he had received the notice whereby the authority had asked for appearance of the employer on 29/4/2013, comma, only on no, it did not receive any notice asking for the appearance of the employer on 29/4/2013. Full stop. In the said petition, comma, it was averred that it only received. What is the actual meaning?
Well,
Paragraph 1, page 26.
the same notice was received on 6/5 along with.
This is not logical, Mr. Counsel. First paragraph. See your content. As per record, the above case was fixed on 29/4/2013 for hearing. An opposite party was asked by the court to appear on that date by a notice issued on so and so. Did you enclose that notice? Something is fishy. Do you have the notice?
Page 8,
Huh?
page 23,
Page
22, madam. Type copy that page 20,
23. Type copy
24. And except.
This is wrong. This is 23rd.
Yes, ma'am.
Your reading is wrong. Is it not? See, Mr. Kathti, your name?
HK.
SK Sharma.
Ma'am.
See, Mr. Sharma. First paragraph.
Yes, madam. The date should have been 22.
This is incorrect. Notice is of, because you say, see, next line. But the OP received a notice on 6/5/2013 along with the award dated 2/5/2013, past in this case, ex parte. So this notice, page 23, was sent to you. Whether you receive or not, that is a different issue. But later on, you received another thing on 6/5/2013 along with the copy of the award. You should have presented the facts properly.
That is even also, that is not award, my lord, it is a order, my lord. Under the payment of this, my lord, it is a order, my lord.
Okay, order award na
Order.
It did not receive.
At
any notice
paragraph 6, my lord, that has been pleaded.
prior to the order dated 2/5/2013 passed in case number PW 06/2011 passed ex parte against it. Full stop. It was contended that he received a notice on 6/5/2013 along with a copy of the award dated 2/5/2013. Full stop. It was pleaded that the applicant, as the employer, had no knowledge of the date of hearing fixed on 29/4/2013, and it came to know about the proceedings before the authority only on 6/5/2013. When the notice was delivered to it by the postal authority. Full stop. It was mentioned that had it been, it was mentioned by the petitioner therein to the effect that had it been notified earlier prior to 29/2013, it could have contested the case and cross-examined the witnesses from the claimant side. Full stop. But since it received the information about the proceedings before the authority, pending before the authority in the form of proceedings of case number PW Swens, pending before the authority only on 6/5/2013, it was prevented by sufficient cause from appearing before the authority on 29/4/2005. Also, with such projections, the petitioner had sought the authority to exercise its power under Order 9, Rule 13 of the CPC to set aside the order dated 2/5/2013 passed ex parte against it. Full stop. Para. On receipt of the said application under Order 9 Rule 13 CPC RW Section 151 CPC, the authority under the Payment of Wages Act, when it was placed before him, after hearing the petitioner side, had rejected the same by the impugn order dated 16/12/2013. on the ground that there is no provision under the Payment of Wages Act to consider the application under the provisions of Order 9 Rule 13 CPC RW 151 CPC. And had observed that to reopen the case after passing the final order. So the authority had further observed that the order dated 2/5 directions made in the order dated 2/5/2013 would continue to stand. Where the on a bare perusal of the impugned order dated 16/12/2013, it is discernible that the authority under the Payment of Wages Act had considered the matter on the premise that there was no provision under the Payment of Wages Act to consider a petition filed under Order 9 Rule 13 CPC RW Section 151 CPC for reopening a case, a CPC, after passing an order on the matter of delayed payment, non-payment of wages and other benefits under the Payment of Wages Act 1936. It is apposite to observe hearing that the order dated 2/5/2013 was passed by the authority exercising the powers conferred on it under the provisions of Section 15 of the Payment of Wages Act. First off, the provisions of Section 15 has provided for claims arising out of deductions from wages or delay in payment of wages and penalty for malicious or vexatious claims. For ready reference, the provisions of Section 15 of the Payment of Wages Act 1936 is quoted here in below paragraph 15. By subsection 1 of Section 15, an assistant labor commissioner by clause C of subsection 1 of Section 15. An assistant labor commissioner with at least 2 years experience, is empowered can be appointed as an authority to hear and decide for any specified area all claims arising out of deduction from wages, or delay in payment of wages, of persons employed or paid in that area, including all matters incidental to such claims. Full stop. As per the provisions of subsection 2, where contrary to the provisions of the Payment of Wages Act, any deduction has been made from the wages of an employed person, or any payment of wages has been delayed, such person himself or any legal representative or any official of a registered trade union authorized in writing to act on his behalf, or any inspector under the act, or any person acting with the permission of the authority appointed under subsection 1, may apply to such authority for a direction under subsection 3. As per subsection 3 of section 15, when any application made under subsection 2 is entertained, the authority shall hear the applicant and the employer or other person responsible for payment of wages under section 3, or give them an opportunity of being heard, and after such inquiry, if any, as may be necessary, may, without prejudice to any other penalty to which so and so related, 2000 posts. Under section 3 of the Payment of Wages Act, and every employer is obligated, is responsible and is obligated for the payment of all wages required to be paid under the Payment of Wages Act to persons employed by it. Full stop. The grievance, the issue raised in the present writ petition is with regard to the rejection of the petitioner's application preferred under Order 9 Rule 13, CPC RW Section 151, CPC. Full stop. Order 9. As per Order 9, as per Rule 9, contained in Order Rule 13, contained in Order Rule 9, CPC. As nalage, as per nalage, as provided. Pera. Again, page 96. The provisions contained in Order Rule 9, Order 9, Rule 13 CPC has, comma, in essence, comma, is, has, in essence, has, comma, in essence, comma, provided for an opportunity to a party to approach the authority who has passed an order ex parte against it, comma, with a prayer to set the said ex parte order first of such ex parte order can be set aside by the authority, provided the party approaching it is able to show sufficient cause that sufficient cause that the notice asking for its, calling for its appearance was not duly served on it, or that it was prevented by any other sufficient cause from appearing before the authority on the date fixed for hearing. Full stop. Fair. To find out the legality and validity of the order, impugn order dated 16/12/2013, in the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India, it is required to find out as to whether the authority under the Payment of Wages Act does not has the authority and jurisdiction to set aside an order passed ex parte against a party in an application prepared under Section 15 of the Payment of Wages. Post. Fair. Okay, doctor. Agora vamos. Rule, sorry, section. The appropriate government or has been empowered to make rules under section 26 of the Payment of Wages Act. Full stop. As per section 1 of section 26, the appropriate government may make rules to regulate the procedure to be followed by the authorities and the courts referred to in sections 15 and section 17 of the Payment of Wages Act 1936. Full stop. In exercise of the powers conferred under section 20 subsection 1 of section 26 of the Payment of Wages Act, the central government has framed a set of rules by the name a set of rules, the Payment of Wages within bracket procedure rules 1937. Full stop. State. Similarly, the state government in exercise of the powers conferred by section 26 of the Payment of Wages Act, has framed a set of rules, the Assam Payment of Wages within bracket procedure rules 1981. Full stop. Subpara. Section
Rule 9.
Rule
Rule 8, madam.
Rule 8 of the Payment of Wages within bracket procedure rules 1937, framed by the central government, has provided as under. Huh? Any? Huh? Oh. And has provided as under and subparagraph. Rule 9 of the Assam Payment of Wages Procedure Rules 1981 has provided that. By a combined reading of Rule 8 and of the Payment of Wages Procedure Rules 1937 and Rule 9 of the Assam Payment of Wages Procedures 1985, it clearly emerges that combined reading of the first provision to sub-rule 3 of Rule 8. It has been cut short now. Instead of 4:30 now 4:15.
Yes.
I was not aware of it. Causley shows 4:15.
This is 4:15.
We will dictate the other part on day after tomorrow. Yes. Because otherwise I am looking at a potentiality that it may be refused also again. So let us make it clear. Otherwise, this kind of, even when power is there, he is not exercising the power. Yes, Mr. Mishra. Heard Mr.
HK, sir.
SK Sharma, petitioner and MCTR. That is Union Government with Assam for the respect number 1. Full stop. As the hearing remain inconclusive, there is the case day after tomorrow as part time. We'll dictate the order at 10:50.
Much.
Yes, Mr. Mishra.
Dues of the previous owners, my lord.
What is Ninan or what?
Dues of the previous owners, he is an auction purchaser.
KC Ninan.
KC Ninan, yes, KC Ninan.
What to do? Are you distinguishing that judgment? Will you be able to distinguish that judgment? Tell me, by any valid ground.
Only difference is that in the carbon resource case, madam, notice that if it is electricity board has given a separate notice with regard to the due. In this case, there is no such notice, but actually, this is a different.
As is, where is basis?
As is, where is
Where is basis.
What to do? You are to be visited with the liability.
3.6.4.
Okay, fix day after tomorrow. There is nothing to, otherwise it is pending.
Pending.
Okay, to লিখে দিব. Please vacation. RS Mishra. Be chosen. Mr. Sharma, what is that? You did not point out on the motion day itself, we should have pointed that out.
That was a mistake on,
Huh?
that was a mistake on our part.
We could have done it. That means in 2014 itself.